A lot of times we talk about MDLs, and a lot of clients and honestly a lot of lawyers that don't do this type of work don't even know what an MDL is. MDL stands for Multidistrict Litigation, and it's just a shorthand way to refer to the type of consolidation of these cases that occurs when you're dealing with a defective drug or medical device or any other tort that has impacted a large number of people. What happens if there are a number of cases that are filed in the court system, usually in the federal court system, at some point you kind of reach a critical mass, and there's a need to have coordination of those cases to just to be more efficient as far as time and money, but also to avoid inconsistent rulings by multiple judges. And so what will happen is either the defendant or the plaintiff can ask that an MDL be established where a single judge would be assigned to those particular cases. In the federal court system, we actually have something called the Judicial Panel on Multidistrict Litigation, which is a group of federal judges that meet every other month in lovely places around the country, and they decide whether a case should receive MDL treatment. There's no magic rule as to how many cases. There have been MDLs that have been established with probably less than 20 cases, and there have been some that have been denied. Generally, you're looking for at least 20 to 50 cases with an expectation that there will be hundreds and hundreds of additional cases, if not thousands. And so the parties go before the judicial panel, and they basically ask that an MDL be established. And they often make recommendations as to one of the judges who already has a case who might be most appropriate. They talk about the locations around the country, and you know, anything can happen at that point. The judicial panel has particular judges that they'd like to give cases to. They also sometimes will choose it based upon the location, whether it's a location that's convenient for the parties, or it just might be a location where there are already a large number of cases that have been filed. And sometimes they pick a location where only one case has been filed, and there's just no planning for that. But that's generally how the process works.
Yeah, we've been really surprised before, after going to the oral argument in front of the judges, everybody walks out of the room thinking, oh, it's going to this particular judge in this venue for sure. And then you get the order from the court and it's somewhere completely different, somewhere that wasn't even asked for by any people in the argument. And so what happens once it's assigned to a particular judge, any case following that's filed around the country in the federal court system, and sometimes even in the state court system, will get transferred, conditionally transferred to that court, and then that court will manage that docket. Probably the first thing the judge will do is, there might be hundreds of cases in front of that judge. First thing the judge will do is realize you can't have 100 different lawyers coming in and talking for 100 different clients. So the judge will establish what's called a leadership committee. Those lawyers are generally lawyers that have established themselves in this kind of work, have experience running litigations, and have the financial resources to actually pay for the litigation. Because what happens is, once the judge assigns the committee, generally there'll be lead counsel or co-lead counsel, then there'll be an executive committee, usually 4 or 5 people, and then there'll be the plaintiff's steering committee. Sometimes 2 or 3 people, sometimes 5 or 10, and in bigger litigations, as many as 20 people on the steering committee. Once the judge does that, those people are responsible for ensuring that that case is properly discovered and prepared. By discovered, I mean you have to get documents from the defendant and review them. Sometimes there'll be millions of documents, and it takes a lot of people to do that. You need to take the depositions of the defendant's key witnesses. Those people will do that. You have to hire experts and go and prepare them so that when it's time for them to be disclosed and deposed, that they're ready to go. That's an expensive proposition. And those lawyers take money out of their pockets and put it in a common fund, and then that money will finance the litigation.
Probably one of the biggest benefits of that process is that you have a single judge who, may have other cases, but this is a big focus of that judge. And so you've got someone that kind of is in the weeds as far as the issues in the case, is touching the case on a regular basis, and it's really, really important to have that kind of commitment by the judge. Most judges have monthly status conferences, so it's not like we're waiting months and months and months to get rulings on the most basic issues, which tends to bog down litigation. It often happens in single injury cases where you might have to wait 2 or 3 months just to get 5 minutes before the judge. So in some respects, that's one of the benefits of the MDL process, is having a single judge who is committed to making certain that the case moves as quickly as possible.
Yeah, and the other difference is there's a significantly different role for a judge in the federal court system than there is in the state court system. In your local state court system, judges generally don't involve themselves at all in resolution. The parties fight and then they might resolve the case or settle the case. In federal court, especially in the MDL process, if a judge has been assigned the responsibility of a major disaster, like the BP oil spill, for example, there was a multi-district litigation for BP oil spill. That judge had a huge responsibility. Injury claims, property damage claims, economic loss claims, thousands and thousands and thousands of people. It's a huge responsibility for the judge. And the judges typically see it as a failure if by the time they send those cases back to the courts where they came from, they don't have a resolution. And in the federal courts, the judges will take a material role in resolution. And so for drug and pharmaceutical cases that have been assigned to an MDL, there's generally a point in time where the court sticks their nose into the middle of the fight between the parties and says, hey, is there some common ground? Can we start talking about resolution? And you don't get that in state courts. That's a big benefit of MDL litigation, one of the big benefits of MDL litigation.